Good morning, Your Honors.
I probably mispronounced your name. Can you?
Reitano?
Reitano?
I think you said it pretty well. May it please the court. In its orders and reasons, the district court concluded that appellant Charlene Moye failed to submit competent summary judgment evidence to create a prima facie claim for disparate treatment and retaliation. The court then concluded, without further explanation, that appellant had not produced sufficient evidence to create a factual issue that her employer's non-discriminatory reason for her ultimate discharge was merely pretext. We respectfully submit to you that the district court's conclusions were based on an erroneous assessment of the evidence. The district court failed to take into consideration competent and substantial affirmative evidence which creates a prima facie claim for disparate treatment and retaliation.
What weight do we place on the fact that she was a probationary employee? What difference does that make in terms of the decision that we make?
I think the weight, where it comes into play for me is that one first, and the court didn't entertain this argument of appellees, that she wasn't qualified. She was qualified to be a probationary employee. Second, it comes into play in that she was being trained. And it sort of disproves the argument about whether her performance was this or that she needed to go back to the new hire orientation program.
Why does that disprove that as opposed to say, people?
Well, because the new hire dispatcher orientation program was a meet and greet. It was a get to know you. It was driving around the neighborhoods and getting to know the precincts. It wasn't on-the-job training in the skills that the actual probationary training trained employees in. So to send her back to the new hire dispatcher program wouldn't have addressed any of the issues appellee was alleging that appellant was suffering or was lacking in.
Well, one of the issues is that she was uncomfortable and lacked confidence, allegedly. Wouldn't make area and riding around and doing all that.
I don't think that would have helped in that regard. I mean, that takes being on the job, having someone sit next to you and give you a comfort level as you're answering phone calls that are emergent, that involve emergency situations. I don't think driving around the neighborhoods would have helped in that situation at all.
Well, but maybe it's not for you or me to second guess what the employer thinks would be helpful when the.
Well, what we're trying to do is just cast doubt on his alleged motivations or reasons for taking the actions that he did. Okay. So the district court not only didn't assess the evidence provided, it failed to view this evidence in its totality, which is important, because each evidence taken in and of itself might not be that significant. But when you look at the evidence and you look at it in a timeline, you see that each and every time appellant engages in a protected activity, i.e. complaining about Sergeant Abadi's differential treatment toward her, giving more attention to her white female counterparts than to herself, not assisting her when she was assisting the other employees, ignoring her, not including her. When she complained that, so first she complained about that, and immediately she was transferred to the night shift. Miss Moye has a school-aged child, and that meant that she had to figure out some way for someone to watch her at night. Very difficult for a parent to do. She's on the night shift. Within a couple of weeks, her supervisor on the night shift, Tanika Tassin, approaches her and tells her, Sergeant Abadi has said that you sound ghetto and that we need to get rid of you. Now, this would make anybody start to feel nervous and uncomfortable on the job. So she again complains, again to Lieutenant Carmouche. And what is the consequence? Within a few days of that, she intercepts a highly offensive email from Commander Baker with language that is offensive, that is racially mocking. This email does not discuss Charlene Moye's performance in any way. Instead, Commander Baker is angry. He is complaining that Charlene Moye has complained. Charlene Moye then, she takes this email, she bypasses Lieutenant Carmouche, and she goes to Commander Cassiope, head of human resources, and she shows him the email. The response to that email was, and she also complains about Sergeant Abadi's negligence and her ghetto comment and all of that. His response was, oh, they didn't mean anything by that. It was harmless. In that offensive email from Commander Baker, he said, let's send her to the jails and make her Jimmy's problem. Let her wash out there. Does that sound like a supervisor who is trying to help and assist a probationary employee trying to learn the job? And what does Commander Cassiope do? He sets up several meetings with Moye during this month. At one point, he even brings in Chief Guidry, Sheriff Tregre's second in command, and they engage in a pressure campaign to send her to the jails. Time and time again, they bring her to the corrections and pressure her to transfer, and she refuses over and over. At their last meeting, what do? They again reiterate they didn't mean anything. They administer a lie detector test to Miss Moye. And what do they want to know? They want to know who told Miss Moye that Miss Abadi had called her ghetto. That's what they were trying to get at. That was the only investigative measure they took. Not to question employees, are the supervisors treating Moye this way? Is there any credence to any of this? No, that was the step they took. After Miss Moye, for the last time, refused transfer to corrections, what did she receive? An order to re-attend the new hire training. Miss Moye couldn't understand this, and she tried to speak with Lieutenant Carmouche to understand the order. She found it demotive. She found it humiliating. She was already in a very humiliating situation at work. And he would not respond to her. On the day of the orientation, he finally answered her phone call. He made it clear that he didn't care about how she felt about this order, and she said, I will attend. But because I typically work on the night shift, I don't have care in place for my daughter during the day. At the time, on August 6th, the school year had not yet begun. She said, I will have to bring my daughter to my grandmother's house, and she was actually in the car on her way, and I will be late to the training. Is that okay? No, not okay. If you're 1 minute late, that's too late. And, yes?
Didn't she already knew that this was...
Yes, I will give you that. She knew, but in her heart of hearts, she
told her right then, you got to get over here and you got to get your child taken care of. She knew about this for some time, that they were requiring her to go to...
But she also tried to engage in a discussion about it for some time. With everything else going on about her frustration, I guess you could say, I think reasonably, got the best of her. She couldn't trust anything her supervisors were calling upon her to do.
Is it true that the supervisors, that they disciplined the employees who made the inappropriate remarks?
I don't believe so. Because, and if they did, it wasn't remedial in any way.
Counsel argues that in their brief, that they...
Well, let's say this. Okay, so a baddie was spoken to, and a month after this all happened, she wrote this note. You know, I used unprofessional language. She dated it, and they stuck it in Miss Moye's file, which nobody ever really looked at. And then Commander Baker was suspended for 1 day.
Isn't that I mean, you may not think the note is good enough, but you...
But the thing is, and this goes to the harassment claim, it wasn't remedial. Though they took these steps, they didn't change their actions. They colluded in emails about, now let's set about creating a paper trail on Miss Moye so that we can get rid of her. That when we get rid of her, we have documented everything. That we've documented her performance, that we've documented if we've given her extra training. It's just not worthy of credence. It's the motivations underlying it are not sincere. And that has to be looked at. It's not insignificant.
It's retaliation in the record.
So retaliation, I think, is all the sequence of events. You complain about me, I'm going to put you on the night shift. You complain about me again, I'm gonna all of a sudden, when her comparator has 0 daily observation reports, we're gonna create 8 within 1 month and stick them in the file. You complain about me, I want you. First of all, you complain about me, I'm going to send you this nasty, offensive email, let you know what I really think about you and and the whole department knows about it. You complain about me, and I let you know I want you to go to the jails, which for no unfounded reason except for the fact that he was angry that she complained about a baddie. And what do? If this isn't, I'm just going to repeatedly drive you over to the jails and tell you that you need to transfer there. And you complain about me. You refuse to do this. And then I'm going to make up this bogus order that you reattend new hire training, which is a demotion. It's an adverse action. It is not trying to give her an opportunity to improve herself.
How is that a demotion?
because she had been working for 4 months and was doing, she might have not been doing everything on their checklist, but she was doing a heck of a whole lot. And before she engaged in protected activity, she received a positive DOR and a commendation.
I understand how that's legally a demotion.
Well, I think the employment and the EEOC, the commission, has said that demotions. I think of it as a demotion because here you are, a probationary worker, and now we're saying you're not even that. You have to reattend a training that you have a certificate that says you successfully completed. You have to attend it again, regain that certificate, and now you get to be a probationary dispatcher again. Thank you.
You saved time for rebuttal. Thank you.
Yes, I did.
Wixom?
Good morning, Your Honors, and may it please the Court. My name is Jason Wixom, and I represent the appellees in this matter. Once again, Your Honor, you have all been presented with evidence that does not appear in the record. The first thing that you heard about was this meet and greet where Ms. Moye was going to drive around the neighborhood. There's nothing in the evidence to suggest that. She was ordered to attend the full training once again because she was not cutting it as a 911 operator. Ms. Moye was a probationary employee of the St. John the Baptist Parish Sheriff's Office who worked in the 911 Communication Center. Sheriff Tregre testified that that center...
You'd be a little bit closer to the microphone.
Sure.
If you would.
Sheriff Tregre testified, thank you, Your Honor, that that center is one of, if not the most important aspects or areas of the Sheriff's Office because you literally have people's lives in your hands. And not everyone can be a 911 operator. Some people
had some positive experiences with emergency calls.
Yes, ma'am. She had one accolade where she...
Two suicidal people, no?
I'm sorry, Your Honor?
She didn't have two suicidal people that she helped?
She was partnered with another person, and they together got an accommodation early on relative to that particular incident.
How would you propose that we handle the retaliation claim legally?
There was...
The court, in its analysis, seemed to use the issue about the comparator, and you don't necessarily need another employee in the comparator situation for the retaliation. So how should we analyze that?
Under the auspices of there is only one adverse employment action here, and that was her termination. Now, in talking about that, there's a difference between what Ms. Moye testified to and what was submitted in response to the motion for summary judgment. Ms. Moye knew for quite some time that this remedial training was coming. During her deposition, she testified that she had a sudden child emergency the morning of. Something happened with school. It got canceled. In our motion for summary judgment, we submitted evidence showing, no, that's not what happened. School had not begun yet. But more importantly, she knew she was going to be late that morning. Does she get on the road immediately? No. She prepares a letter to her supervisor, a handwritten letter saying, I think it's unfair that I have to go to this training. I think it's hurtful and I think it's regressive. And that was her general tone the entire time she was told she had to go. She didn't get on the road to New Orleans to drop off her kid. She wrote the letter. And she managed to make time to give it to an employee. And then she traveled to New Orleans when she was supposed to be at training at 8 that morning. Regardless of whether it's a meet and greet, regardless of whether it's a driving around the neighborhood, she was under a direct order to appear at that training. And let me add for the record, meet and greets are important when you're dealing with things like sheriff's offices or law enforcement situations because it creates esprit de corps. You want to be close to the people you're working with because you need to know that you can count on them. So regardless of whatever it was they were supposed to do that morning, she should have been there. She was ordered to be there, and she knew about it.
Is the training itself, could that be an adverse employment? I'm just trying to legally put this into the normal parameters, march through this case like we would any other case as appropriate.
Of course, Your Honor.
So could they add, because, you know, we have spoken about, you know, these adverse employment actions and in the past year, and so did she argue that that was an adverse employment action, going to the training, and why would that fail?
She argued it, I believe, at the oral argument, but provided no case law to suggest that it is an adverse employment action. There is a case out of this court, Brothers v. Telechecks, I believe I cited to it, that held that asking for or requiring a person to undergo additional training or submitting further record keeping or complaints about an employee is not an adverse employment action, and that makes sense. Imagine a situation where an employee who's struggling is ordered to undergo more training. Well, then they can just say, oh, well, I did this, and you're retaliating against me and making me go to more training.
So the retaliation claim fails because she wasn't, there's no adverse employment action associated with her complaints of being retaliated against.
No,
Is that correct?
that is correct, Your Honor. Again,
What about the harassment claim?
and what specifically are we? And this is important because in the opposition to the motion for summary judgment, she mentioned being transferred to the overnight shift. That does not appear in her complaint. That allegation does not appear in her complaint. Therefore,
That's not for retaliation or harassment, being going to the night shift?
No, she's alleging that it's retaliatory because she made a complaint about Abbott early on. However, that allegation that she was transferred to the overnight shift did not appear until the opposition to the motion for summary judgment. It's not in her complaint. In fact, if you look at her complaint, she doesn't allege that Abbott was not giving her enough attention. She alleges that Abbott frequently followed and monitored her job performance with insulting criticism regarding her decorum and speech pattern. And that is page 13 of the record. There's nothing in the complaint stating that she was not giving her enough attention.
A plaintiff could have a claim for being transferred to the night shift in the abstract, right?
In the abstract, as long as there's
That could be
evidence.
retaliation.
That could be, but certain factors have to be satisfied. Now, those factors are, and this court decided this in Johnston v. Halstead, it has to significantly interfere with outside responsibilities or drastically and objectively be less desirable hours. There's nothing in the evidence to suggest that this significantly interfered with her outside life. Counsel has made that argument, but if you look at Ms. Moye's affidavit and if you look at her deposition testimony, at no point in time does she suggest, oh, being transferred here, yeah, it really created a hardship for me. In fact, she got more attention after being transferred to the night shift.
About her with her child, I mean, she doesn't argue that she's sleepy when the child is home and, you know, that sort of thing.
There's nothing in the record, nothing in the record. There's argument by counsel, and I intentionally attached her full deposition to the motion for summary judgment, and I reviewed the affidavit in preparing for this oral argument, and there's nothing in there that said I had difficulties with my children or...
Back to harassment.
Yes.
The statements and the alleged desire to try to get her to go to the jail and...
So the ghetto comment was racially insensitive.
Okay.
What about the Baker email?
I'm sorry?
The Baker email?
She said during her deposition that she did not consider that to be racial. If you look at page 381 of the record, that's her deposition, she states, quote, Baker was never racist to me. She said the email made her feel uncomfortable because it let her know how he really felt, but she never said the email was racial in tone. She explicitly denied that.
So you're saying it's not severe or pervasive?
It's not, no, and I cite to, I'll put it as case law that is very uncomfortable to read, to show what has been deemed severe and pervasive. This was a one-time, sorry, Your Honor?
Severe or pervasive?
Or pervasive, yes, yes. There's no case law that suggests that using the word ghetto, in fact, there's case law that suggests that using the word ghetto is not severe. There's case law that suggests that using the worst racial epithet you can think of on multiple occasions outside of the presence of the employee is not severe. That is a little...
What did Baker say in the email?
Baker said she's already, pardon my language, she's already starting her shit. She's been told that Leanne is just as bad as her. I'm tired of her. Let's transfer her. I want her gone. Let her transfer to the jail and be Jimmy's problem. If you were to ask me if they liked her, it's likely they did not like her. But she was a probationary employee. If it wasn't working out, she could be transferred to the jail. There were other people in her position or in the 911 position that just didn't work out, and it was suggested that they go to different aspects of the sheriff's office. But importantly, she wasn't transferred. They didn't transfer her. They said in the response email from Baker, we want you to work out. We didn't hire you to fire you. We need for you to undergo additional training. Sure, you think that you only need to go on codes. That's great. I'm your employer, and here's what I think you need. We're not cutting your pay. In fact, now you're going back to the 8 a.m. shift to the 4 p.m. shift. So assuming that there were problems with the child, which is not record evidence, those problems now go away. We want you to get better. And she said, no. The morning of, she said, no, I don't want to do this. It's not for her to say whether or not she needs to do it or should do it. She was ordered to do it. And her termination was a valid termination, legitimate termination under the law. She had the opportunity to present her case to a disciplinary board. She chose not to go. She got an email telling her, hey, this is when it's happening, the date and the time. You may show up. She didn't show up. In the manual, it says if you're subject to a disciplinary action, you may be subject to a disciplinary board. Your attendance is not mandatory, but you may go if you want to. If my job were on the line and there were a board I could go to and say, wait a minute, there's some confusion here, I'd like to clear it up, I would go. She didn't. The only adverse employment action here was her termination. It was legitimate. It was lawful.
What's going on with this lie detector test? That's odd.
She alleges that she underwent a lie detector test. There's no,
Or it happened.
she alleges it. There's no record evidence.
Do they specifically deny she took this lie detector test? Or did they not comment on it one way or the other?
No, they commented on the deposition. They said they were unaware of any lie detector tests that occurred.
Well, who administered it?
There's no lie detector. So I'm being asked to prove a negative. There's no evidence to show. We maintain there was no lie detector test based upon my conversations with the client.
Ask her at her deposition who gave you a lie detector test.
I was not present at her.
Did you give her a lie detector test?
I was not present at her deposition. I don't believe that question was asked. But in the handbook, it does state that if you're subject to disciplinary proceedings, you could be subject to a...
You wouldn't be subject to disciplinary proceedings for reporting that
No.
your boss,
You're correct.
your coworker, boss, whatever they are, used inappropriate language about you.
You're correct. The only record evidence to suggest that it happened is her allegation that it occurred.
Okay.
And even then, that's not an adverse employment action. And Your Honors have no further questions for me.
Thank you, Mr. Wixom. Ms. Reitano for rebuttal.
I want to just address a few minor details. One, the training that she was ordered to reattend was not a full training. It didn't start at 8. It started at 10 o'clock. The importance of meet and greet is just plain silly, since she probably had more experience with the higher level officials at the department than any other probationary dispatcher could have. And this nonsense about in her deposition, she said there was an emergency. She just, at the time of the deposition, just really didn't remember what the case was on August 6th. She just knew that she had to get care for her daughter. And later, when we looked at the dates and saw when the school year started, she realized it wasn't that school was emergently canceled. It was just that the school year hadn't started yet. I also want to read for you verbatim, since you asked, Your Honor, what Commander Baker's email to Ms. Moye said. The email reads in his words, "She is already starting her shit. We picking on her. Jessica doesn't like her. And she was told that Leanne is just as bad, but we ain't picking on her. I'm done and I want her gone. Send her to the jail. Let her wash out there and she can be Jimmy's problem." Now, defense counsel has argued that ghetto in and of itself isn't direct evidence of racial discrimination. But both that comment and this email supply a racial intent, a mixed motive, that it's part of the reason why they did this.
Email provide racial,
Well,
she said it allegedly in her deposition.
I think that I personally objectively think it does, especially on hearing how Commander Baker usually speaks. I thought the way he speaks in this email was mocking, because there was testimony by supervisors that Deputy Moye spoke in slang, grammatically incorrect, and I feel like this, and that's not the way Conrad Baker speaks to you when he is speaking to you, but that's the way he's speaking in this email. So if you put 1 + 1 together, she said she sounded ghetto because she spoke like this, and here, this is the way he's speaking in this email. As to the severe and pervasiveness of the harassment, yes, these were 2 comments, but you have to look at the totality of the circumstances and everything that transpired. She learns about 1 comment, and then she receives this email that she wasn't even supposed to receive. I mean, anyone who received something from someone they had no idea had these thoughts about them, much less the person in utter control of them would feel offended, humiliated, demoralized, and then every other action they took was to fulfill the sentiments of Batty and Baker, which were to get rid of her. And I feel that all the circumstances taken as a whole really call into question every action that eventually led to the ultimate adverse action that defendants took.
Thank you, Ms.
Thank you.
Your case and all of today's cases are under submission.